Hello, everyone. My name is Alan Friel. I'm a partner in BakerHostetler's Digital Assets and Data Management Group. Thank you for joining our program today. Today, you'll be hearing from our esteemed speakers, Shannon Smith and Kyle Dull. Shannon is a Senior Assistant Attorney General and Chief of the Consumer Protection Division of the Washington State Attorney General's Office. Her responsibilities include managing the division's litigation, enforcement, consumer services, and outreach and education activities. In addition to enforcing consumer protections laws, the division is responsible for administering the state's lemon law program and manufactured housing program. Shannon also oversees the Public Counsel Unit, which represents the interests of residential and small business ratepayers in utility regulatory matters. Shannon joined the Consumer Protection Division in 2005 and was named Division Chief in 2012. Prior to joining the Consumer Protection Division, she represented the Washington Utilities and Transportation Commission in telecom and energy reg matters, and the Department of Licensing and Department of Health and Professional Licensing disciplinary matters. She has been with the Attorney General's Office since 1989. Kyle Dull is an Assistant Attorney General in the Consumer Protection Division of the Florida Office of Attorney General, resident in Miami, Florida. His practice focuses on multi-state investigations, privacy matters, and deceptive advertising. He is a graduate of Vanderbilt University and Tulane University School of Law. Kyle is an incoming member of the Florida Bar's Consumer Protection Law Committee. Thank you both, Kyle and Shannon, for taking time out of your busy schedules to speak with us today. Before I get started, a few admin matters. Our program today will last an hour and is approved for 1 hour of CLE credit in California, New York, Pennsylvania, and Texas. New Jersey credit is available via reciprocity. During the course of the webinar, we'll share 2 codes that you'll need to enter into a brief questionnaire immediately following the conclusion of the program. Once the webinar is ended, please look for a small pop-up on your screen. Click Close for your CLE quiz to appear in your browser. Make sure to answer all questions if you would like to be submitted for CLE credit. For other states where we are not approved to provide CLE credit, attorneys can request a certificate of attendance and electronic materials to file directly with CLE credentialing entities. We'll try our best to answer questions at the end of the program, time consuming, but we've got a lot of material to cover. If we don't get to that, we'll follow up with your questions that you submit using the question submission tool on your screen. We'll send an email to everyone in the next few days, also with a linking of the recording of the webinar. Feel free to share it with your colleagues. So with that, let's turn to our conversation. And Kyle and Shannon, could you start us off with just an overview of the legal authority and remedies that each of your offices have to protect consumers? Kyle, why don't we start with Florida?
Sure, Alan. Thank you for having me today. My office's primary enforcement authority is Florida's Deceptive and Unfair Trade Practices Act, which is in Chapter 501. So under 501.204, it states that unfair methods of competition, unconscionable acts or practices, and unfair or deceptive acts or practices in the conduct of any trade or commerce are unlawful. And then by design, there is not a definition of which acts can be deceptive, unfair, or unconscionable. The statute also explicitly states that we are to give due consideration and great weight to the interpretations by the Federal Trade Commission and federal courts. I believe Shannon and I talked about this, but as in Florida, there are numerous per se violations that are established throughout Florida statutes. A per se violation is per se because it contains a declaration that the conduct or violations of the provisions are deceptive, unfair, unconscionable, or they contain unfair methods of competition. In addition to our state statutes, we also use some of the federal rules, such as the FTC's trade regulation rules. For example, one of them that we enforce often is the mail or telephone order sales rule, which prescribes when items must be shipped and refund given. There's also federal statutes and regulations that we can enforce independent of our state unfair and deceptive state statute. For example, the Children's Online Privacy Protection Act imposes certain requirements on operators of websites or online services directed to children under the age of 13. And another one is the Mortgage Assistance Relief Services Act, also known as the MARS rule or Regulation O, which prohibits the collecting of upfront fees in mortgage relief services.
Shannon, how about Washington? Similar to Section 5 or significantly different?
It is very similar to Section 5. And before I go into that, I just need to make a disclaimer that any opinions I might offer during this presentation are mine and cannot be attributed to the Attorney General or the Washington Attorney General's office. The Washington State Consumer Protection Act is very similar to Section 5. It's also very similar to the Florida statute that Kyle just described. Our Consumer Protection Act in RCW 1986 broadly prohibits unfair, deceptive acts or practices in trade or commerce and unfair methods of competition. It's also the statute that houses our antitrust authority. Under the Washington Washington Consumer Protection Act, the Attorney General brings actions and has to prove that there was an unfair, deceptive act or practice that occurred in trade or commerce and that the conduct impacted the public interest. We have a very specific and separate public interest requirement in the state of Washington. Like Florida, our unfair, deceptive acts or practices are not specifically defined in the statute. It's left to the courts to really put the meat on those bones and define for the marketplace and participants what conduct is unfair or deceptive. Like Florida, we have about 140 or so other statutes that contain a per se CPA violation, and those range from any kinds of subjects from funeral home directors to data breaches to telephone solicitation. It really runs the gamut.
So let me ask you both a quick question since we're talking about the comparison to Section 5. So, late 70s, early 80s, KidVid, Congress really pulled back the unfairness authority with a pretty complicated balancing test. Do your states have anything like that, or do you have the older, more, a little more teeth to your unfairness authority?
In Washington, I would say that the law on unfairness is much less developed than the case law on deception. Our courts have acknowledged the sort of pre-1983 or so FTC standard with respect to unfairness, and that is a standard that's been cited in Washington case law, although the Washington courts have noted the sort of the newer standard, if you will, even though it's not new anymore, but the 1980 standard for unfairness that the FTC currently follows. So in Washington, it's an open question, and the law is fairly undeveloped with respect to what is unfair.
In Florida, first of all, I want to mirror Shannon's disclaimer. These are my opinions and not necessarily those of the Florida Attorney General. But one thing is that these per se violations that are found throughout our statutes mean that we don't have to do the full-blown analysis of what is unfair or deceptive because it is a per se violation.
And I would echo that too. When we do have a per se violation, our legislature has declared that that conduct is unfair or is deceptive. So that does lift the burden on us. Where we have undeveloped case law is in those areas where we don't have a specific state statute.
Great. I'm going to move us along, although for the audience, by the way, CLE code Baker 123, that should be easy to remember. CLE code Baker 123. in the CLE materials are a collection of the Florida and Washington statutes that the AG enforces. And we didn't have time to talk about it, but there are a number of very, very specific statutes as well. And I know we'll be getting into a couple of those as we go on into our discussion. But briefly, now we've established your statutory authority. How do you go about exercising it?
Sure. So in Florida, it really depends on the situation. Our statute allows us to send investigative subpoenas prior to initiating any formal legal action in court. This will then allow us to negotiate perhaps a pre-suit settlement with the target, which we call an assurance of voluntary compliance, or we may commence litigation. Again, it depends on the situation. So our remedies are actually laid out in our statute. They include injunctive provisions, obtaining consumer restitution. The big key one here is civil penalties, which can be up to $10,000 or up to $15,000 per violation. And this is a key difference in state enforcement of unfair and deceptive trade practices rather than FTC enforcement. We can also obtain attorney fees. And then we have a general catch-all provision, which allows a court to grant legal, equitable, or other appropriate relief.
In Washington, the relief that we could obtain in the lawsuits that we bring under our Consumer Protection Act are nearly identical to Florida's. We have a civil penalty limitation, though, of $2,000 per violation. We also have injunctive authority. We have the ability to recover our costs and fees, and of course to obtain consumer restitution for those consumers who have lost money or property as a result of a violation of the Consumer Protection Act. Like Florida, we have the ability to issue civil investigative demands that allows us to investigate the conduct and be very careful and cautious before we file a lawsuit alleging that a business has violated the Consumer Protection Act.
Okay, so and some interesting other distinctions there between Section 5 authority, in particular the civil penalties. That sort of brings us to the next question about how do you work with the FTC and say, for instance, each other?
Sure. As Florida, we routinely work with the FTC. A lot of our cases have been in debt relief. We work with them both on joint investigation and co-plaintiffs in federal court. Some of our recent cases include a settlement with a Florida man and his companies, and he used those companies to trick business owners into buying labor law posters by sending mailers that mimic invoices from a federal government or authority. We also participate in joint efforts with the FTC and other federal agencies and the crackdown of illegal robocalls. And that means that Florida will do some filings in state court here regarding about 1 billion calls pitching a variety of products or services such as credit card interest rate reduction services and some medical alert systems.
In Washington, we also collaborate with the Federal Trade Commission. We probably file fewer joint actions with the FTC than other states do, but we have done that in certain circumstances where it seemed to be the best way to proceed against a particular defendant. We do collaborate, though, fairly closely with the FTC. I have regular monthly meetings with my colleagues in the Federal Trade Commission, and we talk about what's on our agendas and what we're working on. And we also share information so that if we see a lot of complaints in our system about a particular business that we think might be a better fit for the FTC's enforcement priorities, we'll send that information to the FTC, and they will do likewise with our office. We also work with other AG offices. There are a number of initiatives that state attorneys general work on together. Consumer protection is one of those areas. I'm sure most of you have heard about multi-state investigations and settlements that state AGs have negotiated jointly with particular defendants.
Now, I'm going to mirror what Shannon said there. Florida is active in this multi-state field. You know, we've recently announced that we're leading a coalition of 39 states that are investigating the business practices of Juul Labs. And there's some other settlements with about 34 attorney generals regarding the nation's largest subprime auto loan company. That was just announced last month.
Great. Let's get into the topic of the day. Unfortunately, in every crisis, there seem to be unscrupulous people and businesses that take advantage of the unwary. How are you looking at protecting consumers during the COVID-19 emergency?
So, Alan, this is a health emergency, and like in other health-related cases, we're seeing substantiated representations about cures and treatment. We're also seeing some misrepresentations about testing kits. That is, the testing kit has been FDA approved, and there are some misrepresentations about home testing kits. So the FDA recently announced that this was authorized, but it's only authorized on a very limited basis. So we're watching that very closely. We don't want to interfere with legitimate testing, but we also want to protect consumers from purchasing bogus or even harmful products. Another key tool that we use is our price gouging statute, which is under 501.160 regarding essential commodities. And I believe we'll talk about that more in the future.
In Washington, we too are looking at issues very similar to those that Kyle just described. With respect to the unsubstantiated representations about cures and treatments, we've seen most commonly in our state misrepresentations about products that will supposedly boost one's immune system to the extent that a person is better protected against COVID-19 or will be better able to fight off the infection if one is infected. We've also seen at least one instance of a fake vaccine, and we have taken formal action against that I think I'll describe a little bit later in the presentation. And like Kyle, we have seen an incredible spike in price gouging complaints for products and services that are related to the pandemic.
Okay. Related to that, with everybody staying at home, we're seeing a huge shift to online shopping. I know personally, my online shopping has increased. What are your offices looking at regarding e-commerce practices?
Florida's looking at general misrepresentations about item pricing. For example, the price of an item changes as you progress through the checkout process, as well as the advertising of fictitious former prices, and that is that in reality, the item was really never available at that previous higher price, and that previous higher price is just being used to make a consumer appear that they're getting a discount. We're also looking at misrepresentations about the item itself. It could not be the item that you actually receive. We see misreps about delivery time, the shipping cost, and then I just also wanted to note that we have worked with many of the platforms, and they've been cooperative in helping us to disrupt and deter bad conduct by removing any of the offensive solicitations. And these platforms also have pretty detailed internal policies regarding price gouging that we've seen them enforce themselves.
And in Washington, we've seen very similar complaints of a very similar nature that Kyle described. We are seeing misrepresentations about the price of an item. We're also seeing a lot of sales by fraudulent or bogus online storefronts. We have seen a number of online storefronts that are popping up on various sale platforms. And when we track down that particular storefront, we see that the storefront popped up just within a matter of weeks after the onset of the pandemic. For the most part, those bogus websites have been selling products that seem to be generating this sense of urgency, like masks and gloves and sanitizing products. And, we have been really quick to notify the online platform, and many of them have been very cooperative in taking down those bogus storefronts.
So, but they're purporting to sell something that they don't have and will never deliver. Is that essentially the scam?
That's essentially what we're seeing. The nature of the complaints we're getting is that a consumer will complain to us and say, I bought a box of masks for $200 and I never received them, and it's been 6 weeks. And from that kind of complaint, when we get a number of those, it leads us to the conclusion that the seller never had the product to start with and is just taking advantage of consumer anxiety.
And are you able to track them down, or is this really a matter of they're up and out so quick and sitting someplace overseas that it's difficult to actually find the bad guys?
It's a mix.
Interesting.
Yeah,
it's a mix here in Florida too.
Okay, let's stay on COVID for a little while. What kind of COVID-related complaints are you seeing, and what's the volume?
So in Florida, we're a fairly large state. We have about 12,000 contacts from consumers during the current state of emergency. Consumers are requesting refunds for vacations, such as canceled hotels, rental houses, car rentals, cruises, as well as price gouging for essential commodities.
And in Washington, we're seeing much of the same thing. We're seeing numerous complaints about requesting refunds for membership fees and payments to gyms and exercise classes, in addition to all of the travel-related refund requests and cancellations. We're seeing consumers ask for refunds for private school tuition, summer camps. We're seeing a lot of consumers complaining about not being able to get refunds for venues that where they've paid a deposit for a wedding or other event that's been canceled because of the COVID-related emergency. We've seen essentially a doubling of the consumer complaint volume in our state since the pandemic.
How do you deal with this increased volume? Obviously, you can't investigate every one of these complaints. How do you prioritize, or is there some way to try to encourage voluntary retailers and consumers reaching a resolution themselves?
When we receive consumer complaints, we generally try to work with the business and the consumer to informally resolve that complaint. But given the volume, it's been very difficult to manage that. We have tried to manage this volume by reaching out to businesses by having our attorneys, which is not something that is in our ordinary practice, but we're having lawyers call businesses to alert them to the complaint, the nature of the complaint, and our view about how the complaint might violate the Consumer Protection Act. Those aren't enforcement calls. Those are essentially calls to alert the business and try to see if we can't effectuate compliance.
Alan, I'm going to mirror what Shannon said there. We're doing very similar things here in Florida. It's been all hands on deck since about March and even before then.
Sounds like you need an army of interns. All
And
right.
nice.
Um, so let's concentrate on price gouging a little bit. It's not well known. It's not a well-known statute or claim. Comes up after hurricanes, and Florida knows a little bit about those. But what's the legal basis for regulating pricing of products? And when do we go from free enterprise to consumer protection? What limit? What kind of limits on price increases do your state laws permit? How do you go about calculating what is acceptable and not? And just how does all this work?
Sure. In Florida, as you mentioned, we have hurricanes, so that's how we got our price gouging statute. As I mentioned, that's under 501.106, and the title of it is the rental or sale of essential commodities during a declared state of emergency, a prohibition against unconscionable prices. So, of course, the statute does not define what is an unconscionable price increase, and we don't have a specific benchmark. What the statute does say is that prices are prima facie unconscionable if there's a gross disparity between the sale or offer price now and the average sale or other price of the commodity in the 30 days immediately before the state of emergency, or the current price grossly exceeds the average price at which the same or similar commodity was readily obtainable in the trade area during the 30 days immediately prior to the state of emergency. And then in Florida, our law covers any goods, services, materials, merchandise, supplies, etc., that are necessary for the consumption or use as a direct result of an emergency. Usually in states of emergency, with hurricanes, that deals with plywood, fuel, water. In this current health emergency, we consulted with the Florida Department of Health to determine what commodities were essential and identified the major categories. Those categories are disinfectants, sanitizers, and face masks. And we also, I want to note that we do have an ability to bring an enforcement under a general unfair and deceptive statute rather than the specific price gouging statute. And then similar, we're seeking the same things in these price gouging settlements, which are injunctive terms, consumer restitution. The civil penalties are a little different here. It's a $1,000 penalty for each violation, up to $25,000 in a 24-hour period. We're also seeking attorney fees.
And in Washington, this is where we are very different from Florida with respect to this presentation. Washington does not have a specific price gouging statute. So we don't have any law that we can enforce against price gouging other than our Consumer Protection Act and the broad prohibition against unfair or deceptive acts or practices. So that would be the authority that we would use. It has been untested in price gouging, but that is our authority. And, you know, we would file cases under our Consumer Protection Act. Our focus is very similar to Florida, given that this is a health emergency, and the products that we've been most interested in have been the PPE products, masks and gloves and hand sanitizer, disinfecting wipes. We've also seen a lot of issues with respect to bath tissue and other paper products. And we've seen some complaints that we generally don't see with respect to unanticipated increases in food prices.
So we were talking about some of the examples, and Kyle, you were talking about, 300% increases for sanitizer or Clorox wipes or Lysol. There's a difference, isn't there, between having stock on hand and quadrupling the price of it in the wake of an emergency, and then just the realities of supply and demand. If you're making hand sanitizer and your raw product cost go up because there's a lot more demand for them, and you're just trying to make the sanitizer and take a reasonable profit, but not a gross profit. Is that a defense? In some states, the price gouging concentrates on the profit margin. It sounds like each of you are concentrating on the historic price of the product, but wouldn't it be a defense, or would it be a defense, or potentially a defense in your states, if the retailer or even the manufacturer distributor could establish that they were not gouging, but themselves being gouged, but continuing to be part of the supply chain, and taking a modest profit? Have you come across that?
In Washington, and we don't have a specific price gouging statute, and I think in some states their statutes will address your very question. In Washington, the situations we've seen where there's a 600% increase in the price of Purell or a 400% increase in the price of masks have generally been because the retailer sees an opportunity, given the situation, to increase those prices and increase the amount of profit that they're able to make. Those aren't supply chain issues. Where we do see supply chain issues, I think under our statute, because we're enforcing a law of general applicability, we would look at the totality of the circumstances. And perhaps if the retailer or the manufacturer is seeing an increase in acquisition costs or production costs that is reflected in the price that they sell it to the consumer, we may not consider that a violation with respect to those entities. We might look deeper in the price chain, though, to see if there's any opportunistic pricing or price gouging by other participants in the chain. So to answer your question directly, whether or not that could be a defense, I think depends on the totality of the circumstances.
I think Shannon hit the nail on the head there. We're doing a very similar thing. I also want to note that we do have settlements where price increases are 270% to 350%. This isn't a threshold in Florida for what constitutes price gouging. They're just extreme examples. In other states of emergencies, it's been a much lower increase. We've had settlements of 20 to 30% increase. And again, everything depends on the facts of the case. And then we look at price increases, and we do look to see whether they result from additional costs or market trends.
And how are you going about, I assume you're getting a huge volume of these complaints. How are you going about weeding through them? Are you doing any in-store visits? How do you go about trying to get voluntary compliance? What's the experience been like the last 60, 90 days?
In Washington, since the pandemic began, we've received over 1,200 complaints about price gouging. And in response to those complaints, we have made nearly 400 in-store visits to brick and mortar stores in Washington to verify the pricing. We've also done some looking, as I described earlier, into online marketplaces, and have inquired of the platforms and have inquired of the retailers themselves. We've sent cease and desist letters to some of these organizations or some of these retailers or sellers, and have worked on, really, trying to get all of the market participants to understand their obligations. We have not yet filed any formal actions with respect to price gouging, but certainly those aren't off the table.
Again, we're doing something very similar here in Florida. We do have people looking at all of the complaints that come in. We have investigators and attorneys, and we have reached some settlements with companies regarding this current state of emergency. For example, one of them was an ABC, which is an assurance of voluntary compliance with a used car dealership in the Tampa area. They sent out some advertisements and they advertised a tent sale purporting to have COVID-19 relief funds available to consumers. And it advertised that consumers can claim stimulus funds at a designated stimulus temporary relief site. So in that settlement, we got injunctive terms preventing any future representations in consumer restitution, as well as a civil penalty. And as of this morning, the Federal Trade Commission announced that it filed a complaint against the marketing company Traffic Jam Events LLC, which was used by this car dealership in Tampa. And that complaint was filed in the Eastern District of Louisiana.
Well, and that's an interesting point. Unlike your hurricanes in Florida, I suppose Mount St. Helen blowing up in Washington, thankfully that's not happened recently. COVID is uniquely worldwide, right? And these are not local scams or local problems necessarily. How are you working with each other and the FTC to address the bigger operations?
So in Florida, we might refer complaints to other states to investigate if it's an out-of-state company.
I think we would do the same in Washington. We've had, as I mentioned earlier, my communications with my colleagues in the Federal Trade Commission here in Washington State have been more frequent. We have been sharing information about the entities that we're seeing. It's been a fairly unique situation for the reasons that you described. This is a global pandemic. I think it's taken a lot of people by surprise. And so, we're seeing some scams that are really typical scams, but they've been sort of cloaked in this COVID mantle, if you will, like the fake cures. I mean, there's nothing unusual about sort of the so-called snake oil, but when you put the COVID label on it, it sort of increases the awareness of law enforcement, whether that be state AGs or federal regulators. And so we're always, I would say, and we're all in very frequent communication with each other about the various scams that we're seeing that are popping up.
And so, Alan, also in Florida, we confer with other states to discuss emerging enforcement issues. But I want to note that the price gouging laws are state specific, so each state would have to bring its own enforcement action. However, if there are issues that arise involving unfair or deceptive practices that might impact multiple states, then we would consider a multi-state investigation, and we are actively doing that. For example, with some of the travel refund issues, we are coordinating with other states whose residents are impacted by canceled travel plans in Florida. This includes airlines, car rental companies, hotels, home sharing platforms, and the cruise industry, as several of the major players have corporate offices here in Miami.
And one other thing I would add too is that our office sent a cease and desist letter to an individual named Johnny Stein and his business called North Coast Biologics for marketing and selling for $400 a vaccine for COVID-19. He is a microbiologist, so he has some understanding of the science, but the vaccine was not tested. At least that's our allegation. We had sent a cease and desist letter. Weeks after that, the Federal Trade Commission and the FDA sent a cease and desist letter. My office filed a lawsuit against the individual and his business last Friday. So that's another example where you have a state agency, the AG's office, and federal agencies looking at the same individual or business and the conduct that's precipitated by the COVID emergency.
So that's interesting, Shannon. Frequently, whether you're at the FTC level or the state AG level, you don't see the complaints filed unless either there's a settlement and it's part of the settlement, or you've got someone that's just not playing ball. In this particular case, is this because of the need for injunctive relief and the stop the harm to consumers, or are you more likely to bring cases rather than try to reach a consent decree and a settlement?
I would say, Alan, that we don't limit ourselves to either track. This individual took down the Facebook page that he was using to advertise the vaccine once we sent the cease and desist letter. So we had, we weren't, we didn't necessarily feel like we needed an immediate injunction. But we did feel like we needed a lawsuit in this case. But we still will, as we discussed earlier, perhaps file a lawsuit simultaneously with the settlement that we've negotiated pre-filing. I would say that our office, the Washington AG's office, in the last 6 or 7 years has been filing more lawsuits rather than pre-file settlements than we have in prior years. So I think it really depends on the situation, and it depends on what we think is the best way of using our authority.
And I'm going to mirror what Shannon said for Florida. Exactly the same situation here. It really depends on the situation, how severe the complaint is, how sufficient or the amount of evidence that we have. And we do the same thing. We might file a complaint and file a consent judgment at the same time. As you know, some of these pre-suit settlements might take a while, and we're very interested in stopping the bad behavior as soon as possible.
All right, let's move on past COVID because the world has not stopped. Before I get into privacy and data security, CLE code Baker 456. Remember, the first was Baker 123. The second is Baker 456. So our privacy and data security issues over the last 90 days uniquely COVID-19 oriented, or is it more of the same? What's your privacy and data security docket's been looking like lately?
So in Florida, it's not necessarily COVID related. There have been some articles and interest in the plans to use phone location tracking being used to trace COVID-19. But as you know, almost everyone is working remotely, and therefore more people are engaging in video conference calls. You've seen a lot of news about reports of Zoom bombing or Zoom attacks, which is the phrase used to describe the unwanted intrusion into a video conference call by an individual, and they disrupt the call with inappropriate or offensive material, named after the popular video conferencing app Zoom. So we are looking to ensure that companies do offer sufficient encryption and take other proactive steps to protect its users. We're also, you have a lot of kids at home, so this brings up issues with children's privacy, because many schools have switched to distance learning via these video apps. And we're also looking, for example, we recently sent a letter to TikTok, which is a popular social media platform for information on its privacy practices and how TikTok ensures the privacy and security of children who use its apps, and as well as requesting documents showing compliance with the Children's Online Privacy Protection Act.
Yeah, in Washington, I would say we're having a similar experience as Florida. I mean, all of those issues are on our agenda. Privacy and data security are some of our enforcement priorities here in Washington. And yes, there are concerns about things like contact tracing. That's both sort of a public health initiative and there are also some commercial applications of that. There are also issues about children's privacy and data security as people are working remotely. I think as states start to open up and businesses start bringing their employees back, some of the health screening issues that come up as a result of that could create some health privacy issues. We'll have to see what happens and how businesses are safeguarding any health information that they obtain or maintain about their employees as they try to screen them and ensure that their workplaces are conforming with whatever back to work requirements or best practices that they're following.
So each of your state legislatures have been looking at a CCPA or GDPR inspired specific privacy law. Those haven't gotten out of the legislature in the last couple sessions. So what are your current laws in Florida and Washington State for security and breach notification and for a privacy-related consumer protection?
Sure. At least in Florida, a lot of it revolves around our Unfair and Deceptive Trade Practices Act, and we look to see if the policies are, unfair or deceptive.
That's the same in Washington. In the absence of a specific data privacy statute, we rely on our Consumer Protection Act largely as the enforcement tool. There are some very sort of specific niche statutes in Washington and probably in other states too that protect certain data, depending on sort of the classification of that data. But overall, we would rely on our Consumer Protection Act.
And you both talked about COPPA, that's the Federal Children's Online Privacy Protection Act, which gives state AGs authority to enforce directly. And it sounds like children's privacy issues are at the top of the priority list. Are there other issues, for instance, maybe in Florida with respect to seniors? How do you go about looking at which of these kind of cases are important to you?
Florida has a large population of seniors, so we actually have something called the Senior Protection Team, and it's dedicated to investigating and prosecuting these scams. One thing that we've done now is that in addition to our consumer protection enforcement, we've brought in our Office of Statewide Prosecution to prosecute some of these scams criminally if we can.
And in Washington, we prioritize cases against vulnerable consumers, whether they be senior citizens, whether they be folks who might have language barriers or other kinds of barriers that might make them more susceptible to scams. And we're always looking for businesses that tend to prey on consumers who are particularly vulnerable to whatever that scam might be. For example, seniors who might be not as technology savvy as others might fall victim to certain kinds of scams. And so we're looking at those kinds of scams as enforcement priorities. We also look in terms of our priorities at what is the degree of consumer harm It's very important for us to stop conduct that's causing widespread or very significant consumer harm. So sometimes the conduct may not necessarily be widespread, but the harm may be incredibly great, but to a smaller number of consumers. We would be very interested in that. We're also interested in conduct that occurs in, perhaps newer technologies or newer business models, to make sure that as those technologies or as those business models take hold, that we could perhaps set some standards about conduct to prevent it from becoming more pervasive.
And then, Alan, another thing I wanted to mention is that in addition to privacy issues with children, another priority for our office is in the investigation of the vaping industry. Prior to this COVID-19 state of emergency, we had issued over 20 investigative subpoenas to vaping companies throughout the country. And recently, we filed litigation against 2 of the companies based here in Florida, based on claims of unfair and deceptive marketing of their e-cigarette products. However, in general, we're looking at the marketing practices and the online sales strategies of these companies to determine if they've unfairly or deceptively targeted minors. And we will also seek information to determine if the companies can support their marketing and health claims.
So we've got several hundred lawyers and marketing executives on the call today. And the BakerHostetler client base looks to do the right thing. And these people are here to hear from you as to what you think that is. So what are the other enforcement priorities that may not go to the level of bad actor, but just sort of best practices and the standards that your law applies to marketing and sales practices that we should be cognizant of? What are the things that a good acting company or marketing agency needs to be wary of to make sure that they're staying on the right side of the line with you?
In Washington, I would say a couple of things. If there is a disclaimer in any kind of advertising, that should be clear and conspicuous. If there are any conditions to a particular offer, make those clear and conspicuous. Tell the consumer exactly what you're marketing, what the limitations are, whether or not there are any disclaimers. Do that clearly and conspicuously in the marketplace or in the advertising, so the consumer knows what he or she is buying or signing up for. I would say another thing that's important in advertising, if you're making a certain kind of claim, a health claim, an efficacy claim, perhaps an energy savings claim, those kinds of claims, have substantiation for those claims. Don't make unsubstantiated claims. Have the substantiation necessary for that marketing claim.
And if I if I don't have the substantiation, but I can come up with it post hoc, is that going to get me a free pass with you, or the fact that I made the claim without knowing whether or not it was capable of substantiation, is that gonna sink me?
That would be a problem in Washington under our understanding of the law and recent court decisions.
I think I'm going to mirror what Shannon said. Pretty much the same situation here in Florida. And one thing, generally not just about their policies, what we appreciate is when a company is responsive to any inquiry from our office. If it's just us sending a complaint to the company, a quick response, acknowledgement that they've received the complaint and they'll respond, that's something that goes a long way with us.
And what do your offices do to educate?
I would echo that for Washington too.
But we try to be responsive.
What
What
To educate businesses.
yeah, exactly. What tools and resources are available out of your offices that our clients could look to for guidance?
So in Florida,
We have
I
some
would
business
point it.
best practices. Go ahead.
Oh,
Go ahead, Kyle.
okay. Just quickly, in Florida, I'd point companies to our website, myfloridalegal.com. It will have our settlement, our ABCs, our complaints on there, so companies can see what issues that we're looking at, as well as our press releases.
I would echo that for Washington. We also have some business resources on our website as well.
And talking about those prior settlements, those consent orders, you know, there's been this debate within the consumer protection legal bar about whether or not there's a common law of consent decrees, that whether or not there should be any kind of precedential value to a settlement between a government agency and a single actor. And the academics love to write law review articles about this. But practically speaking, how do you look to your prior enforcement actions when determining what the state of understanding ought to be for marketing and sales practices? Do you see those as merely individual settlements that have no precedential value, or do you look at them as sort of guideposts to industry that you expect people to adopt and conform their practices around? How much of it is just fencing in authority that doesn't necessarily apply to everyone else? How much of it is a message to industry that this is what you need to be doing?
In Washington, I would answer that question by saying it's not really either or. I would say that our consent decrees are not precedent. We are certainly not bound by those. So if we enter into a consent decree with one business about certain conduct, it may look very different if we were to have a consent decree with a different business. That said, though, I think where it's most relevant is to look at the injunctions and look at the development of those injunctions over time. And I think that's where you would see, not necessarily precedent, but I think that's where you would see our sense of what conduct is unfair, deceptive, and needs to be stopped.
I'm going to mirror the same thing here in Florida. It's really a mixed bag. I think that posting these online give a great guidance to allow companies to know what we are interested in looking at. Of course, you're not going to see all the facts about the situation that resulted in that settlement in the ABC. So again, take everything with a grain of salt.
All right, well, I'd like to thank you both. Oh, go ahead, Shannon.
I was just going to add that, consent decrees are negotiations between our office and another entity. So there is a lot that goes on in negotiations that may not apply to another actor.
That's certainly my position on it, but they are indeed also guideposts. Thank you both so much. This has been a great conversation. I know that our clients really value it. We appreciate the work that you do for us as public servants. And I personally appreciate the time that you took out of your busy schedules today. So with that, I remind all of our participants to take the survey and put in those codes, Baker 123 and Baker 456, to get their CLE credit. If you're in a state that we do not have prior CLE credit for, you can get a certificate that you can file with your own state, and they generally accept them. It's subject to each state bar's rules, but we'll try to help you get credit if you need it. Finally, before I sign off, I encourage people to subscribe to our two blogs. We have an advertising blog and we have a data privacy and protection blog. And you can visit them passively, or you can set yourself up to get email alerts when we post. So thank you, everyone. Have a great day and be safe out there.